Hey guys, and welcome back to Gov with Gabby. My name is Gabby Zanis, if you don't already know me, and I'm here to go over McCulloch v. Maryland, which is a required court case on the AP Gov curriculum. First, what are the facts of the case? What do you need to know? Well, this case took place in 1819. So pretty much in 1816, Congress had declared that the Second National Bank of the United States had been chartered, which is targeted at significant political opposition, or people who didn't really want this at all. And several states enact anti-bank laws because they didn't want the Second National Bank of the United States. They thought it was unconstitutional. They thought it was a political power overreach. So Maryland's law placed a tax on all banks operating in the state that are not chartered by the state. Pretty much, the tax is aimed squarely at the new federal bank that the United States government had just chartered. So what happened? The cashier of the Second National Bank, James McCulloch, where we get the McCulloch and McCulloch v. Maryland, refuses to pay this tax. So then Maryland sues the bank and McCulloch, and Maryland wins in the Maryland courts. But then what happens? Well, our big issue at hand is, does the federal government have the constitutional authority to charter a national bank? Is the government even allowed to create a second national bank? And if so, does the state of Maryland have the authority to then tax said bank? That's the big question. Well, what does the Supreme Court say? Because the case goes all the way up to the Supreme Court, and even though Maryland said, yes, of course Maryland has the power to tax, well, the federal government, according to SCOTUS, or as we call the Supreme Court of the United States, says, yes, the federal government does have the constitutional authority to charter a national bank. Yes, you can issue the Second National Bank. Yes, you can charter the Second National Bank. That is within your constitutional authority. The establishment of a national bank is a legitimate exercise of congressional power. It's not an overreach. It's well within the necessary and proper clause, which is not a enumerated power, but it is an implied power. But the second part, because this is a two-pronged question, is no, the states do not have the authority to tax this federal bank. So even though you disagree with the Second National Bank, you cannot tax it, Maryland. That is wrong. That is unconstitutional. That is bad. So this says allowing states to tax the national bank and the national government would interfere with national supremacy. Yes, we're in a federalism system. Yes, states and the federal government work together, but there is a certain degree of national supremacy, which makes the Constitution different than the Articles of Confederation. The Constitution is supreme. The federal government is supreme. So if states were allowed to tax the national government, this would interfere with the balance of power. So the states are not allowed to tax the national government. The Constitution, it grants several powers, including the power to borrow money, tax and coin money, and regulate commerce, all of which may be facilitated through a national bank. So the national bank allows for several of these constitutional powers to be carried out, including the power to borrow money, to tax and coin money, and to regulate commerce. And although the establishment of a bank is not one of Congress's enumerated powers, or in other words, one of the powers that was explicitly laid out, number 1 through 17, it does fall well within the necessary and proper clause, which says that all laws that are necessary and proper to carrying out all of the other said laws can be done under the federal government. The National Bank is helpful and appropriate means for Congress to implement its enumerated powers. Under the necessary and proper clause, it says, yes, you can make any laws that are required to carry out the enumerated powers or the explicitly stated powers. And the Supreme Court says yes, that the National Bank does that. Furthermore, under the Supremacy Clause that is found in Article 4 of the Constitution, the state of Maryland did not have the authority to tax the National Bank because, quote, the power to tax involves the power to destroy, end quote. Because that was seen as a political power overreach, or too much power to the states and at the loss of the national government. This was a foundational case, and it broadly interpreted the scope of the necessary and proper clause. If you can see, this case took almost all of the power in this situation away from the states. It said, yes, the federal government can create a national bank, but no, the states cannot tax it. So this ruled heavily in favor of the power of the federal government and the supremacy of the federal government and it broadly interpreted the Necessary and Proper Clause. The Necessary and Proper Clause granted Congress implied powers, or powers that are not explicitly stated, but they're used to carry out the explicitly stated powers, called the enumerated powers. Secondly, the Supreme Court relied on the Supremacy Clause to invalidate the state law to tax the national bank, which contradicted the federal law charting the bank. This makes McCulloch v. Maryland an extremely important case in the foundation of our history, because we're seeing how the balance of power between the state and federal governments has been a slippery slope and broadly debated. There are so many areas in our Constitution that creates a power overlap, or a question of who has more power, who controls this, the state or the national government. But McCulloch v. Maryland sets a precedent, or a rule that will be followed in further cases unless the precedent is overturned by the Supreme Court, that all of these cases that deals with a national bank or states taxing the national government, the power in the decision is in favor of the national government. This case further affirmed the supremacy of the national government. The power in this case went to the national government. Thank you guys so much for tuning in to AP Gov with Gabby. I hope you learned a little bit more, or a lot more, about McCulloch v. Maryland that happened in 1819, a required case for the AP government exam. Please, please, please subscribe or turn on your notifications if you love AP Gov or you want to get a 5 on your exam in May. Hope to see you back again sometime soon for our next required case. Thank you!